Hi, I'm Jim Fausone with Fausone Bohn, a law firm in Western Wayne County, and I'm sitting today with Abigail Richards, one of our family lawyers here at the firm, and there was an interesting Michigan Court of Appeals case about emails in the divorce arena. And Abby, I thought it would be good to hear your perspective on this recent Michigan Court of Appeals case.
Thank you. Michigan Court of Appeals recently decided that an employee may not have a reasonable expectation of privacy if they use their work emails to correspond with their divorce attorney. So what the Court of Appeals found was if an employee is provided with a handbook showing that they do not have a reasonable expectation of privacy, that the emails may be monitored at any time, that they cannot expect for attorney-client privilege to attach to their email communications.
That's pretty standard in the employment business that your employer says, hey, if you're using my computer and my email, I get the chance to look at your emails, so you should know that it's work-related, it's not private and confidential. Isn't that kind of what you've run into in your practice as a family lawyer, Abby?
Yes, of course, and we always recommend that our clients set up a separate email address for them to use that they know is private, not a work email, not an email shared with a spouse, just to make sure that they are going to have that expectation of privacy with any of their communications with us.
Could you explain what the expectation of privacy allows for? If you don't have it, that's what got in trouble here. But if there is an expectation of privacy, what's that mean as somebody communicates with their family lawyer?
So what that would mean, and specifically in this case, the employee's wife attempted to subpoena the email communications between the defendant and his attorney. And because there was no expectation of privacy, she was going to, depending on how the trial court ruled, have access to those emails and see what was communicated between the two of them. If you do have a private email server and you are communicating with your attorney through that, then those would not be discoverable by the other party.
So that's pretty good advice. Make sure if you start on this process of a divorce proceeding that you have a private email address that you can use where that expectation of privacy exists, and therefore the attorney-client privilege exists. Abby, if people have questions about this or just family law in general, how do they reach out to you?
They can call me at 248-912-3238, and I'll be able to answer any of those questions.
Well, we're glad to spend a little time with Abby Richards today on a family law matter, an interesting little wrinkle out of the Court of Appeals, and we appreciate you listening to this today.
Thanks for watching. Fausone Bohn, LLP is your premier full-service law firm based out of Western Wayne County, Michigan. If you have questions, reach out to us at 248-380-0000 or check out our website at fb-firm.com. Connect with us on social media on Facebook, Twitter, LinkedIn, and YouTube.